Hi, my name is David P Shapiro. I'm the owner and managing partner of the law office of David P Shapiro, located in San Diego, California, where my firm helps good people regain control of their future when charged with a crime. This video, I want to talk about a couple of ways that you could get your DUI charges, particularly your DUI murder charges, dismissed in San Diego. The first way is if you take your case to trial and the prosecutor is unsuccessful in getting all 12 jurors to agree beyond a reasonable doubt that the only reasonable interpretation of the evidence is that you committed the crime of which you're charged. Okay, so you go to trial, you win. Not guilty. There you go. Case is done. Let's say you go to trial and a jury's deadlocked, right? And you hear a hung jury. Maybe it's 9 people want to convict and 3 are not sure. Or it's 11-1. Or it's 6-6. Or maybe 10 people say not guilty. A lot of times what will happen is the jury will deliberate, and when they say they're hopelessly deadlocked, the judge will declare a mistrial. And then the prosecutor could potentially dismiss charges. They're unlikely to do so at that point, given the severity of the case. But a court could intervene and say, hey, I don't think any reasonable jury could ever convict on these facts. So I, as the judge, am going to dismiss. Well, those are 2 examples about how you get your case dismissed or win at trial. Well, what if it's not a great case for trial, right? A lot of times these cases are not the greatest cases to take to trial. Sometimes you go to trial just because you really have nothing to lose. Other times you go to trial because you have this great factual issue. But sometimes you have situations where the blood alcohol level is really high, driving admittedly was really bad, and as you know, in order to be charged with DUI murder, that means someone had to have lost their life as a result of some accident or collision. Well, what do? Do you throw your hands up and say, well, this is terrible. I'm going to face my punishment and just give up. Well, you shouldn't, because there are some other ways you could get your DUI dismissed. Let's talk about a motion to suppress evidence. Motion to suppress evidence is when something is done in violation of the law, and we're asking the court to throw out the results of what was obtained and everything after. A lot of times we see it in felony DUI cases, DUI murder cases, even your basic misdemeanor DUI, as it relates to a blood draw. So let's assume there's a situation where you get arrested and you're refusing to consent to a blood draw, right? You're like, go get a warrant. And the cops get a warrant or they don't get a warrant and draw your blood, right? Well, you could challenge the warrant, you could challenge your actions, and the argument would be, once the needle went in the arm, if that was illegal, then everything, including the results of that blood transaction, the results should be kept out of evidence. So if you're successful in that, now the district attorney can't use that blood alcohol content. They can't use the toxicology screen. They can't use anything that comes as a result of that. Well, how are they going to prove you were 0.08 or higher at the time? How are they going to prove you're under the influence of alcohol or drugs at the time? Well, you see, their job becomes a lot more difficult. And that's another way you could get a dismissal of a DUI case, including a DUI murder case. Last option for purposes of this video is something known as a 995 motion. These apply to felonies. You have a preliminary hearing, judge says there's enough evidence for the charges to move forward, and then, either during the hearing or after, you're like, hey, we think the judge made a mistake, whether it is an issue of fact or whether it's an issue of law. You could file what's known as a Penal Code Section 995 motion, basically asking a different judge to interpret the transcript, match it up with the law, and entertain your argument that, hey, the preliminary hearing judge got it wrong. The remedy should be a dismissal of the charges. Judge hears the evidence, reviews the transcript, there's some oral argument, and hopefully, if the law supports it, will dismiss the case and the charges against you. This video has gone over some ways that you could basically either beat a DUI charge, including felony DUI, DUI murder, all the way to keeping certain parts of evidence, key evidence out, which ultimately result in a dismissal. Not all hope is lost with the high blood alcohol level. Not all hope is lost because of the tragedy that one or multiple people lost their lives as a result of a DUI fatality. You still have rights. You still have the option to defend yourself. You still have the option to hire the best quality, locally experienced criminal defense firm that you could possibly afford. We are just one phone call away and can be reached at 619-295-3555. Again, my name is David Shapiro, San Diego criminal lawyer.